Well, hello everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is April 27th, and glad that everybody wants to come out and hear this show. Honestly, it is so much fun for me, and hopefully that you'll also be getting something out of this legally. Um, it is the opening talk that I want to talk about is dealing with the new security deposit laws, more harm being foisted upon us by our elected officials, certainly in the state of California. It's crazy that they just keep coming up with more and more ways to hurt landlords, but of course they have. One protection that landlords have when they rent out a unit, obviously, is that they have the ability to take 2 months' rent as a security deposit. That would be 3 months for a furnished unit, 2 months for an unfurnished unit, so that at least if a tenant creates damage to the unit, you have some retribution in terms of getting compensated for that damage. Or if the tenant skips out owing you rent, then obviously you're going to be able to use that security deposit for those items. So the legislature, in their ultimate wisdom, decided they were going to change the law. That law is changed as of July 1st, 2024, so coming up in a couple of 3 months. And so what is that new law, ladies and gentlemen? That new law is that a landlord is limited, with some exceptions, to only 1 month's rent. Well, we know how long it takes to do an eviction. We know the damage that a tenant can cause, which can be in the thousands of dollars. So to limit a security deposit to only 1 month's rent, in my mind, ladies and gentlemen, is just criminal. It's just creating so much additional expense for landlords, and there's really no reason for it. The legislature stated that this was necessary, that they had to do this because God knows it's difficult for tenants to get into possession of a unit. If your rent is $2,000 and you wanted to get a 2 month security, that would mean that the tenant would have to pay a total of $6,000 upon move-in. And God knows the legislator thought that that's really just too difficult. So let's make it easier for them. Well, the truth is, what that does is it makes it much more difficult to landlord to be compensated for any loss of rent, any loss of the damage. Plus, the fact that a tenant doesn't even have 2 months rent and a security to move into the unit, I mean, that's just a wonderful credit check in and of itself. If a tenant doesn't have that wherewithal, then it's probably not a good mix because, for example, if the tenant's car breaks down, then what does that mean? He's going to use that money to pay for his car versus the next month's rent. So it's really putting landlords in such a terrible position that we now have to do something different. So what's the difference? Right now, I think you have to raise your criteria for leasing out a unit because you have no protection. There's no built-in protection with only 1 month's rent. So if you had a criteria, for example, that I need a person's credit score to be 650, well, maybe now you need it to be 675 or 700 so that you have at least a shot that the person who's moving in will be a responsible tenant, will take care of the property and pay his rent on time. So the first thing I'm suggesting is, come July 1st, the next time you rent out a unit after that time, that you raise your criteria. So in other words, for all the politicians listening to this, you've just made it worse for tenants to get in possession because any landlord with any smarts is going to want to raise the criteria because you're only going to have 1 month's rent in your pocket in case anything goes wrong. Now, I did talk about it on my tweet today on my X or Twitter that there is a way to get around this, and there is a little bit of a way to get around it, so I want to go over that with you. There is an exception to the security deposit law that you are you are allowed to take 2 months' rent if in fact you have no more than 4 units in a total of 2 buildings. So if I have 4-unit building, one building with only 4 units in it, I am entitled to get a security deposit equal to 2 months' rent. But if I own 2 4-unit buildings, or conversely, let's pretend that I own 5 single-family residences all over the state of California, well, that would mean that I would owe more than 4 units. So based on that, what I suggest you do, if you have 2 4-unit buildings, for example, I would put one at least in an LLC. By putting one in an LLC, then that building is owned by that landlord. That landlord is not you. That landlord's an LLC, and you can own the other building in a regular individual status or in a different LLC. Maybe you have 5 different 4-unit buildings. So as long as you're not over the magic limit 4, put them all in different LLCs. This way, for each building, they have a different owner, and that owner only owns 4 units. So that's one of the ways we've been kicking around here at the office to move things along so that landlords can get at least 2 months' rent. But again, you are limited to 4 units in 2 buildings, a total of. So that's my discussion today on the security deposit. Once again, that's going to become effective as of July 1st, 2024. Be sure to explain to your politicians that you're going to make it much more difficult for tenants to rent from you. You need to have a higher standard because you can only get a 1-month security deposit. And if you do have the types of buildings, 4 units or less, you can also increase that by putting them into different LLCs. That being said, we're going to open it up to landlord-tenant questions right now. I want to advise you that if you do want to talk, all you have to do is electronically raise your hand. It's so on the toolbar on your screen there, and I'll know to call on you. Please do not talk unless I do call on you. And we have to remember that this Zoom meeting is for informational purposes only, and it does not take the place of quality legal help, even though I have been an attorney now for 47 years. And last but not least, if you do have a case with me at my office, God bless you. I'm happy to help you, but we keep these discussions only for general legal questions. If you do have an issue regarding your case, happy to talk to you. Just give us a shout out on Monday and we'll happy to discuss your case. That withstanding, we are now going to open it up. And I know a guy by the name of Tony Castellone. If you please unmute yourself.
Thank you, Dennis, for taking my call. First of all, I just want to thank you for all that you do for us, small pop landlords. My question is, I have a handyman that I went to do some repairs, and he informed me that the tenant have a large dog. I sent a text to the tenant. He admitted. I give him a 3-day notice. But when I went back to reinspect the unit, he took the dog off the unit, and when I left, he brought it back. So I want to know.
Well, if you serve a 3-day notice to perform or quit, giving the tenant 3 days to get rid of the dog, and then on the 3rd day, he moves the dog off the property, but then on the 10th day, he moves the dog back, he's now not in compliance with your notice, and you can immediately start an eviction case based on that. The only exception would be if you've accepted rent after you've served the 3-day notice, then you're going to need to serve another notice, because once you serve this 3-day notice, anytime you take rent, you've basically forfeited that notice, and you're going to need to serve another one. So if you haven't taken rent from this person and you now see that the dog is there, you have a wonderful case to commence an eviction.
Thank you.
Okay, Tony, thank you for asking that question. Norman Lagerquist, I'm going to ask you to unmute yourself.
Good afternoon, Dennis. If you issue or terminate a lease, but the tenant doesn't vacate on time, are you under obligation to provide habitable living space at that point, or can you start a remodeling project that involves turning off water and power and so on?
And the answer is absolutely not. You can't stop giving services or not take care of a unit just because you served a proper termination notice. You have to go through a regular eviction case. Once the tenant is formally evicted from the property, then you're allowed to do your remodeling.
Okay, thank you.
Thank you. We're going to move along to Anna. Anna, I'm going to ask you to unmute yourself. Anna, are you there?
Hi, Dennis. Yes, I am. Can you hear me okay?
I hear you loud and clear, young lady.
Okay, I got a little thing going on here I wanted to explain to you. I have a tenant who's always been a little difficult when it comes to me entering her apartment. She insists on being there when I need to enter, which doesn't bother me until now. She gave me a list of a few maintenance requests she needed to have done and some touch-up paint in the kitchen. She also told me in her request that she had called the gas company, but I'm not sure exactly why. I never got an answer. So then the gas company issued a hazard condition ticket on the stove. So we called the gas company to schedule an appointment for them to come out to explain to us their concern. And so I went ahead and made the call on Wednesday, the 17th, and the next available date for them to come was on Friday, the 26th, yesterday. We scheduled the repairs for her maintenance request, and then I was there on Tuesday, the 23rd, and each day we were there, I continued to give her notice that we'd be coming back the following day to finish up the maintenance. And then so the last notice I gave her was Friday, or Thursday, that we'd enter on Friday to keep the appointment with the gas company to see what the problem was on the stove. And the appointment was set between 12 and 5. And then on that day, at 6:30 in the morning, I get an email and a voicemail from her, and she told me she was unavailable. But, you know, I went ahead anyway to meet with the gas company from 12. I was there waiting, and then, you know, for 5 hours almost, about 4:15, I called them up to see if they were coming. And then I was told that she canceled the appointment at 5:30 the night before, only she never notified me. So I had a repairman there with me. So we went ahead and entered the apartment and looked at the stove. And then he said he noticed that a burner didn't seem right. So he took it off, removed it. We unplugged it, disconnected the gas. And then I left her a note saying that she shouldn't use it. I'll have to come back. Well, then she comes home around 7 o'clock and then calls me up. And she was belligerent and wanted to know why I was in the apartment and why didn't I notify her and why didn't I communicate with her that I was going to work on the stove. And then she just kept going on and on. So
Well, let me stop you here because we're going pretty far afield with this. Obviously, in terms of the law, if you serve a 24-hour, at least a 24-hour access notice to make a necessary repair, it has nothing to do with the tenant's consent to enter. You have the right under Civil Code 1954 to enter that unit to make that repair. So you did nothing wrong in going there with your handyman and to check that out. I would advise the tenant that if in fact she ever tries to prevent you from going in when you serve the proper access notice, that would be grounds for eviction. So right now, I presume you still have to repair the stove. Is that correct?
yes, it is.
And do you know what needs to be done to get it corrected?
Well, based on what the repairman said, I needed to replace the burner, so he has it on order, and I haven't made.
All right, so I would send a letter in writing to your tenant, which basically states that you went in because you served a proper access notice. Again, that if you try to prevent me from entering with a proper access notice, that's going to be grounds for eviction. Tell the tenant that we have already ordered the part and we expect it to be there on a certain date, and then we will offer you a new 24-hour access notice to go in. But again, you did nothing wrong, and again, you can do a little bit of a threat to her. Anyway, thank you very much, Anna, for your question. We're going to move on now to Diana. Say hello, or Diane, excuse me. Diane? Are you there? Diane D. Last chance, young lady. Oh, there you
Dennis,
go.
I'm sorry. I'm visiting my mom in the hospital. Can you hear me?
I hear you.
Hey, I just wanted to know, um, I had, raised rents like you had suggested because we had very low rents, way under market, and feeling guilty I didn't raise them really enough, and suddenly I'm hitting like a lot of really huge repairs. And can I raise them again, or is that going to get me into trouble?
Well, let me ask some questions. First question, what city is the property located
It's
in?
sorry, City of Los Angeles, all single family homes.
Okay, so it's only a single family home, one house on the lot, correct?
Yes.
Under the Costa-Hawkins bill, you can raise the rent as much as you like, whenever you like. So you can serve another notice. Obviously, it's going to be above 10%, so you're going to need to serve a 90-day notice. And you always, if you mail it, unless you hand it to the tenant, you're going to need to add on an extra 5 days. So a 90-day notice would be 95 days.
Right. Okay. Got that. And thank you for that. And also, I had contacted your office regarding what the minimum rent increase or the maximum rent increase in a duplex in Port Hueneme, and I was unable to get the correct information from other places. And Sally, who I talked to, was very diligent and got me the exact information. And so I got my rent increase out yesterday. So to make the 95 days or 30 days plus 5. So thank you
got
for
it.
that.
All right. Well, thank you. I'm glad you dealt with Sally. She's one of the best we have here.
She's lovely.
I am going to move on now to Anthony. Anthony, say hello. Mr. Anthony. Give you one more chance, young sir. Okay, let's move on to Marco. Marco, I'm going to ask you to unmute yourself.
Hello. Yes, I have a question about in cases where tenants don't pay the back COVID rent. Can you say when landlords it's better to choose to evict them instead of small claims, especially, if eviction could be more costly and take more time?
Okay, so what Marco is talking about is that a tenant is probably paying current rent, but never paid that rent that became owed during the COVID period because the tenant was claiming that he was financially impacted by COVID. It's really a personal decision whether you bring forth an eviction, which you have the right to do in most cases, or go to small claims court, where when you sue in small claims court, the jurisdictional limit is $12,500 this year, but for COVID rent, it's unlimited. So the issue is, do you still want, if you go to small claims court, that means that the tenant's still going to be in possession of the property, still going to be paying you the rent. I don't know if you're suing him, it seems like that relationship is probably going to really go downhill after that. So it's whatever you feel comfortable doing. Most people in that situation are going to just want to end that tenancy with that individual. But you're right, eviction cases don't take a day or 2 days. I had a client the other day say, well, we served the 3-day notice and I thought you were going to have the sheriff come the next day. And I said, no, ma'am, that's not exactly the way it works. So yeah, they do take a while. The sheriff's office is having a lot of delays. So we're looking at 2.5, maybe to 3 months before a tenant actually gets evicted. So it's really your comfort level and the economics at hand.
Okay, thank you.
Okay, we are moving on to Hovig. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
I'm a realtor. I just wanted to call and ask a couple questions so I may properly advise my client before we submit an offer on a property we're looking at.
Hovig, what office are you with?
Coldwell Banker, Hallmark.
In what city?
It's in Glendale, California.
And do you do residential sales or commercial?
I mostly work with clients who are looking to expand their investment portfolio. So some condos, duplexes, and multifamily.
Sounds good. Everybody out there, you need a realtor. Hovick seems like he's on the no based on trying to get this information. So Coldwell Banker Glendale office, correct?
Yes, sir. Thank you.
Ask for Hovick. But in any event, what's your question, sir?
So the property in question is in North Hollywood. There's two houses on one lot. The house that my client wants, the property that my client wants to purchase also wants to move into that front house. It's built in 1940s, and the tenant's been living there since 2003, I believe. Also, obviously, needs a lot of remodeling as well. So I'm not sure what the right way to kind of proceed on an eviction. What would you suggest?
Well, a tenant, the landlord, or excuse me, the new owner certainly has the right to move into the house. You'd have to serve on that tenant generally a 60-day notice. You are going to have to pay relocation. If it's a single family home with only one house on the lot, then you need to pay the relocation, which is only 1 month's rent. So that would be one option. Another option would be if he wasn't going to move in and he just wanted to renovate it, then in that situation, the law does allow you to evict a tenant for renovation, though it does require that the renovation is going to take longer than 30 days to complete, where the time and the place would be uninhabitable for that period of time. And he also has to pull permits like an electrical or a plumbing permit.
After he does the renovation, is he allowed to move into the house?
Oh, yeah. Yeah, he can move in or he can re-rent the premises for whatever he wants to.
It's up to him. Okay, and then last question. There is a second house on the lot, so it's two houses on one lot.
Okay, so let me stop you here. Everything I just said thrown out the window because we said it was a single family home. I thought I said with one house. Now we've got two houses. If we've got two houses on the lot, then you're subject to the rent stabilization ordinance. You can't do a renovation eviction. You're only limited to having the owner move in.
Okay. And the second property, the second house that's on the lot was built more recently. Is there a rule of thumb of when it would be exempt from citywide rent control?
Of course, if it was built after October 1st, 1978, then it would be exempt from the rent stabilization ordinance. You are still subject to the just cause ordinance, but for that house, for example, you could ask the tenant to move on the basis that the owner wanted to move in, though you would have to pay a little more compensation, relocation. Also, you could raise the rent on that one as well, at least 8 point. Depending on when it was built, you might be able to raise it unlimitedly if it was built within the last 15 years.
Got it. And if it was built 25 years ago?
Well, if it was built 25 years ago, then you're under the statewide rent control for that house, and it's 8.8%.
Got it. Okay. Thank you, Dennis.
No problem. We are moving on to Laura Corral. I'm going to ask you to unmute yourself.
Hi, good afternoon, Dennis. Thanks for all the valuable information you share with us. So my quick question is the following. So our insurance carrier is requiring that we update our electrical panel. We're in the process, we got the permits, we got a good rate and so forth. But it's really costly to go ahead and replace an electrical panel of a 6-unit building. Now, this year we were able to increase the rent by 4%. And my question is because the cost of repairing the electrical panel in the building is $30,000. Would I be able to increase rent again, or do I have to wait till next year? It's within
Okay.
RSO and LA County.
Okay, no, you're not allowed to increase the rent. You'd have to wait till next year. However, you might want to apply for a capital improvement rent increase. So
Okay.
that's some paperwork that you file with the city. If it's approved, and this would seem like it would be approved, then the tenants are responsible to pay 50% of the cost, which would be, in your case, about $15,000. However, it's amortized over 5 years. So they would, and it's be like, I don't know, like $37 a month or something to that effect, where you can get a rent increase for that capital improvement. You got it?
Okay. Yeah, because LA Housing Department said I could only increase it to 5% for 2 years.
That makes no sense. I don't know who you were talking to. You need to apply for a capital improvement. Then assuming it qualifies, then 50% of the cost is then shifted to the tenants, but it's amortized over 5 years.
Okay, okay. My
And in
other
fact, I've
quick
done that
question.
with my building. I have a building in Studio City. We did that with the soft retrofit, and they're paying, I don't know, like $37 is the maximum they can pay.
If I want to go ahead and paint the entire outdoor building, do I need to get a permit for that?
That I don't know.
Okay,
But I do know you need to get a lead paint specialist if your building was built before 1978.
got it. Thank you.
Thank you. Okay, we're moving along. We're doing pretty good here. Jim Polina, I'm going to ask you to unmute yourself.
Hey, Dennis, how's it going?
It's good.
All right. So I got some great tenants in the city of Pismo Beach, 4 hours north, and I want to convert the garage, which they make use of quite a bit, into an ADU. So they currently have a 12-month lease, which automatically renews, but I want to stop that. I want to change them to a month-to-month, and then eventually take away the use of the garage. So I'm not quite sure what's the best way of doing that, a change of terms or a new lease.
Okay, well, first of all, you say the lease automatically renews. Why do you think it automatically renews?
The last paragraph states so and references a state law about that.
Is it in boldface type?
12 point.
And
Yes.
it's got to be in two places, boldface type, one by the signature at the end.
I only have it in one place at the last paragraph by the signature.
Yeah, I'd have to check that. I think it needs to be in two places, but notwithstanding, you're right. It is going to renew itself. But I'd have to check the lease to see if there's any way for it to stop being renewed. If maybe you have to serve a notice 60
no.
days before.
Yes, correct.
Okay, so serve your notice 60 days before. Now it's going to become a month-to-month tenancy. Since this is a single-family residence with only one house on the lot, once it's a month-to-month agreement, you could give them a 30-day notice that they will no longer have the use of the garage, that you're taking it back. They want to move, they want to move, but that would certainly be yours. So we've got to stop, and I don't think it's wise to have an automatic renewal provision in a lease. Very few landlords do it, my good friend. But in any event, definitely comply with the terms of the lease by serving that notice so it doesn't automatically renew. Once it becomes month to month, serve a 30-day notice that they're losing the use of the garage because you're planning on building an ADU.
Okay. And then finally, this idea of what you talked about, the security deposits, 1 month terms or 1 month max. I read about this idea of offering them an insurance policy that pays the security deposit and any potential damages. Have you heard of this, and what do you think of it?
I have not heard of that. So what you're saying is you're going to tell the tenant that he has to pay for this insurance policy, or you're going to pay for it?
Security deposit replacement insurance. He pays for it either on a monthly basis or a lump sum.
Again, it's going to be looked at as a security deposit regardless. So the payments, if they equal more than 1 month's rent, I think you'd be flying in the face of the law. 50 years ago when I went to law school, how long ago was that? I do remember a phrase that a law professor once told me, and that phrase was, "The law is not an ass. And what he meant by that was that the law will always look through the form to the substance. And what you're doing is you're trying to get around that security to law. The method that I'm doing it is proper because it says a landlord may not. Well, I'm not the landlord on this property, this LLC is. So I think my idea, assuming you don't have an 8-unit building, then you're dead. But if you have 4 units or less and you have multiple units, you can get around that by doing LLCs.
And I assume
Anyway,
a land trust,
go
I
ahead.
assume a land trust work the same way as the LLC,
The what would?
a land trust.
I don't know if, because usually on a land trust, that's going to be a trustee of the trust, which would be the same. So I'd have to think about that, to be honest with you.
Okay.
Anyway, thank you very much. We're going to move on to Ashok. I'm going to ask you to unmute yourself.
Yes, sir. Can you hear me?
I can.
Okay, so we have a tenant. He pays every 6 months. And when the city of Los Angeles allowed us to raise rent effective 1st of February, he didn't calculate, or actually he's behind rent because he paid up till May. And now I'm trying to ask him to pay the increased rent and he's not responding.
So what you're saying is that the tenant pays the base rent, but he didn't pay the increase, correct?
Correct.
Okay, so this is what you're going to do. Come May 1st, you're not going to accept rent unless he pays you the complete rent that's owed. So all the, since February through May, he didn't pay the rent increase. So add that to May's rent. Now, the reason why I'm telling you to do it that way is because Los Angeles has what they call a threshold. You can't serve a 3-day notice unless it's above the threshold. How much is how many bedrooms are there?
It's a single unit, market rent around $1,600. He pays $650.
Okay, so it's an efficiency unit or a single, so you have to be above $1,777 in your 3-day notice. But if he, I would imagine that if he didn't pay the increase for 3-4 months now, plus that 1 month's rent. So just tell him, I'm not accepting May's rent unless you pay me every penny that you owe. He'll be above the threshold. Then we'll be able to serve a 3-day notice, and then we'll be able to proceed forward with an eviction.
I think it'll take another 2-3 months to get to that threshold.
Well, it would only be 2 months because
Yeah,
the threshold 1777. How much is the rent per month?
$650.
Oh, it's only $650?
Right. So
Right. Oh, yeah. Well,
he doesn't
then
even live there. You know, he lives somewhere else.
certainly stop taking rent unless he pays the full amount.
Okay, one quick more question. He pays every 6 months. Can I give him 30-day notice and say, hey, no, I'm only going to accept once a month?
Well, was that the way you set it up with him, to pay
No.
once every 6 months?
We purchased the property with that setup.
So he has a rental agreement which states that?
I'm going to double check, and it might though. It might. I'm going to double check.
And you can do a change of terms of tenancy. I don't see any problem with that because you're not really increasing rent. You're just increasing the rate, the factor of when he has to pay the rent. So I think you could do that. In
Okay.
any event, thank you very much, Ashok. I am moving on to, let's move on to Suzette. I'm going to ask you to unmute yourself. Suzette. Suzette, if you're not there, we will move on. Let's move on to Harold. Harold, I'm going to ask you to unmute yourself.
Right. How's it going, Dennis?
Always good when you're on.
We're not happy about the Lakers, though.
Well, let me tell you something. I'm going to be, truth be told, I'm going to the game. It starts at 5:30, so I might end this broadcast a little bit early to
Oh my God.
downtown.
Say your
But
prayers for the Lakers.
Yeah, you know, we went to Denver and saw the first game there. Of course, that didn't come out too well.
Mhm.
And we were staying at the Four Seasons with the Lakers, of course. And then all of a sudden I see a bunch of Secret Service in the hotel. I'm going, what the hell's going on here? And Joe Biden was in the hotel too. And she didn't even call me up. I could have told her all about how bad government to tenants. But in any event, why don't you ask your question, young sir?
Okay, so just a hypothetical, if I raise the rent to market rate and the tenant says, I'm not gonna pay it. And then, 90 days later, I think it's a 90-day notice, right?
If you're going above 10%,
Right,
correct.
okay, so 90-day notice, rent comes due, he doesn't pay. Does that then become an eviction situation and I have to wait because of the threshold to evict?
Well, it
Or
all depends. How many bedrooms?
it's only one is being rented, but it's a house, a
Okay,
single
so-
family.
Got it.
single
So
LA
he's,
type.
so he's one bedroom, and how much is his rent after you raise it?
Let's say it's like 12-ish and then raise it to 18.
Okay, so you're gonna need to wait 2 months because for a one bedroom, the threshold is 2006, so it has to be above that.
So it'd be a standard eviction. It'd probably
Oh, yeah.
timeline probably be I'm out 4 months before the guy's out.
Well,
So-
2.5, you have to wait 2 months, and then it's gonna take 2.5 months. Yeah, this is our government at work for us.
But the other possibility is if I can negotiate, here's your money, get out of here, and then go through you guys to set up an agreement, right?
We certainly can help you with a voluntary vacate agreement.
Okay, thank you, thank you. Go Lakers.
Thank you. Okay, I think I see Suzette. I'm gonna give you another chance to unmute if you can.
Can you hear me?
I can. Look at you. Are you driving right now?
Yes,
Well,
but
let
I
me
put
tell
the
you
phone
something.
down.
I do not do personal injury law. So please, whatever you do, do not hit the car in front of you.
I'm not going to. I put the phone down.
Very,
Okay,
very
I
good.
have two questions. So my tenant was successfully evicted. The sheriff department locked them out. They left a lot of stuff in there. So when I send the itemized,
Let me stop you here. Let me stop you.
okay,
If the sheriff did the lockout, you don't have to send any itemization. Those items will be deemed abandoned 15 days from the date of the lockout. There is nothing further for you to do except to wait for the 15 days. When the 15
Okay.
days goes forward, the tenant has the right to call you up and make an appointment at your convenience for that tenant to pick up his treasures that he left behind. Now, if he doesn't, then after the 15 days, you have the right to toss that stuff in the garbage unless it's worth $700 or more in total. If it is, then you're going to have to hold a public auction.
okay, perfect.
There's
And
no
then-
form for you to fill out only because the sheriff did the lockout. If the tenant just moved, let's pretend the day before the sheriff was doing the lockout, then you would need to have that quote abandonment of personal property form, which, by the way, is on my website at evict123.com.
Well, they were not there when the sheriff's department came.
Right, but the sheriff, they never gave you possession. The sheriff did the lockout with
Yes.
you. They have 15 days from that date, young lady.
Yes, okay, perfect. And then my second question is, when I do the, you know how within the 21 days, you have to document the damage and you send it to the tenant, right?
That is correct. And you also deduct for all the rent they owe you. So in other words, while you have to do the itemization, you're not giving them back a penny.
Right, so they live, I own the duplex, so I live next to them. They didn't give me a forwarding address, so it's gonna go to my building where I live, but their unit. I have the key to the mailbox, so when I send that letter, they're not gonna get it. So what do I
Well-
do? Take it out of there and throw it away? I mean,
Well, the law provides that a tenant is supposed to do a forwarding address. So hopefully it'll never get to that mailbox because it'll be forwarded to his new address. If in
okay.
fact it does get in that mailbox, then the tenant's gone legally. So you would just write the word moved on the envelope and give it back to the postman.
Okay, perfect. Thank you. Go Lakers.
Hey, thanks. You know, we have the Nuggets just where we want them. We're down 3-0, so we're going to win 4 in a row, okay? And we're going to make NBA history, and then we're going to win the whole championship, and I'll be at the parade on Figueroa. But
And I
thank
will
you.
meet you there.
And I haven't been drinking, by the way, ladies and gentlemen. Let's move on to well, we see we got some let's try Anthony. We did one with you. Let's try again. Anthony?
Yes, Dennis, thank you so much. I tried to unmute myself earlier, no success, but now I have. Thank you. Question on extreme hoarding, single-family dwelling, not responding to corrective notices. And I understand I can do something like motion summary judgment because it seems to be, untriable. We're not trying to prove anything. It's just unlivable. And
Well,
so,
first, yeah, you're getting ahead of yourself. First of all, if a person is hoarding, most hoarding is extreme. That's why they use the word hoarding. So the bottom line is every rental agreement, and you said this was a single family home with only one house on the lot, but every rental agreement states that your tenant has to keep the premises in a neat and sanitary condition. Anthony, what city is this?
this is in Los Angeles.
Okay, so you do need cause to evict, so that
Right.
would be the cause. You'd serve a 3-day notice for the tenant to clean up. At the end of the 3rd day, if the conditions remain the same, then we have the right to go forward with an eviction. Now, usually in hoarding situations, it's what they call excess clutter. Usually these people have things stacked up throughout the apartment where there's only a short path to which to walk through. They have things blocking wall heaters and things blocking windows. So this is really a safety hazard. Is that pretty much describe what I would see if I walked in?
To a T. Everything you think would be safe is violated.
Right.
Exit,
So
exit,
again,
exit
you don't,
heaters.
you talked about a motion for summary judgment. Well, first, you have to file a lawsuit and then serve that lawsuit. And if the tenant doesn't contest, there is no such thing as a motion for summary judgment because you're just going to take a default. But if the tenant did contest, that would still be what we call triable issues of fact of the condition of the premises. So on that basis, I don't think what they call an MSJ, a motion for summary judgment, would work. However, you do have a very clean case for eviction.
So we don't want to go to trial, right? It's like, why are we going to trial? This is
Well,
not,
again, you're not going to trial unless the tenant contests. You don't know if the tenant's going to contest.
well, let's
You're getting
assume
ahead
he
of
does.
yourself.
Yeah, assume he does because he has that disposition.
If he does, I would think it's dubious whether you can go forward with a motion for summary judgment or not. So you'll spend a bunch of money. The judge will declare that there are triable issues of fact, and then you'll have to go through the trial anyway. So in most situations, but it depends on what he said in his answer.
Okay.
That would make me persuade me to tell you that yes, this qualifies for it. Very few cases qualify for a motion for summary judgment.
I see.
Anyway, thank you very much.
Just one follow-up question, quick.
Sure.
Health department citation, would that be helpful to get a
That would be helpful.
And what the agency does that from your experience?
You just call building and safety and have them come out there, or the Los Angeles Housing Department, one of the two.
Okay, very good. Thank you, Dennis.
Thank you. We're going to do a couple more here because I see a couple more hands. Let's go back to Tony Castiglione. Ask you to unmute yourself. Hello, Tony. Tony, are you there? Okay, Tony, we gave up.
Can you hear me? Can you hear me?
Now I
Can you hear
can.
me? Oh, Dennis, thank you for taking my call. While I was in the webinar, I got a phone call from my handyman, and he said, by the way, the tenant that has the dog, he has the garage full of big containers with flammable liquid, maybe gasoline. So I'm going down there Monday to check. Do I have to give him another 3-day notice for that?
No,
well?
I don't know if that would be in violation of the contract to store, quote, gasoline. I'd have to see what the contract says, and you don't even know what's in there for all you know, it could be snowflakes. So, but again, you already have grounds for eviction on the basis that you served a 3-day notice and the dogs are still there. So you're good to go, young sir.
All right. I will call your office Monday. Thank you so much.
I'll be here. Okay, let's move on to, I think I'm going to do our last call before I skedaddle off to where am I having dinner tonight? Fleming's across the street from the arena. Let's go to Julie. Julie, we're gonna wind it up with you. Say hello.
Hi, Dennis. Thank you for taking my call. I have two quick questions. Number one, I have a tenant whose lease is ending in June. I've waived their last month's rent. I'm trying to get them to sign a voluntary vacate agreement, but they're refusing, saying that they're going to get out and that they don't need to sign it.
Well, what city is this?
LA.
And is this an apartment or a house?
It's a house.
Well, tenants don't have to sign a voluntary vacate agreement, hence the reason why they call it voluntary.
Okay, your office, I had talked to your office last week and they had suggested that I get them to sign one as a
Yeah,
precaution.
if they're willing to sign one, that would be great. But if they're
Okay.
not willing to sign one, what are you gonna do?
Okay. And then my second question is, I'm putting the house on the rental market. I can still provide 24-hour notice to bring my realtor in so that he could take a look at the property to see what needs to be done.
Absolutely. It
Okay.
should be normal business hours, Monday through Friday, 9 to 5.
Okay. And if they refuse to let us in?
That would be grounds for eviction. You know, you can also, if it's a single family home, you can also raise the rent to whatever you like, and that usually has a way of getting rid of people.
Okay. All right. Thank you.
Thank you. Let's move on to, I'm going to go take one more call. Jessica Rogers, I'm going to ask you to unmute yourself. Please unmute yourself, young lady. You're having technical difficulties.
There, now it's working.
Yes.
Awesome.
Hello,
Thank you
darling.
so much. I've had like the
You
worst.
snuck in as the last call.
Thank you. I've had like the worst week of my life. I'm so grateful that I get to speak to you right now. You can hopefully answer some good questions. I have an issue with my tenant. It's a single home, and it's just gotten really weird.
What city?
Pacific Palisades, so city of LA.
Okay, it's a single family home, only one house on the lot.
Correct.
Is the tenant on a month? Is the tenant on a month to month?
It is a by default month to month because the 2-year lease expired.
Exactly. And does the tenant owe you money?
No.
Okay, then tell me what the problem is, young lady.
The problem is that I want to terminate this agreement.
Why?
And she recently discovered that her son has breathing problems, and she is now obsessed and is being very unreasonable. Her husband is not. He's being very cooperative. I'm currently in the house right now.
Okay, you're breaking up a little bit. Hopefully you can still hear me, but you're not telling me. You say she's being unreasonable. That tells me nothing. What is she doing?
She's just very paranoid and scared and wanting me to open up all the walls in the house and asking for things that are unreasonable. And she's being very
if something is unreasonable, it's very simple. You say the word no. I'm not opening up the walls in my house. Okay, if you want to go get yourself some purifier, air purifier, because you're so concerned about your child, great, go do it. I don't care which one you buy, just buy it yourself. And if you're not happy, you can always move. You need to have good cause to evict for a single family home in the city of Los Angeles. You just can't serve a notice to quit as we used to be able to do in the past. So you have to have a reason. So the fact that she's annoying you is not really a good reason.
So even if it's month to month, I can't just say I'm moving on.
Unfortunately, no. You have the right to raise the rent significantly. You can do that, but you'd have to have a reason. And the fact that she's making you a little bit crazy with regard to her request is not grounds for eviction.
Okay. All right.
Thank you very much.
Thank you so much.
So, ladies and gentlemen, I'm going to call it a day. I know I didn't get to talk to everybody. I am sorry, but guess what? There's always next Saturday at 3 p.m., or you can always call our office at 1-800-77-EVICT. I enjoy the fact that we do these meetings. You know that it'll be posted on YouTube. So you'll get to see yourself play back on this. And once again, thank you, everybody. And the Lakers are going to win 4 in a row. That's my prediction. Take care, everybody.